Massachusetts. Court is now open. You may be seated.
Good morning. Good morning, Mr. Lynn.
Good morning. May it please the Court, Paul Lynn for the Commonwealth. The Commonwealth's position in this case is not that any one of the factors present in this case would have justified the threshold inquiry. It is the combination of factors. It is the straight-arm method of walking, first of all.
But what did that look like? Can you demonstrate it?
I did not actually see. I was not actually there, so I can't actually say. But
well, I know you weren't there. But, oh, okay.
Yeah.
Was it demonstrated at trial?
It was demonstrated at the hearing.
You said a combination of factors justified the threshold inquiry?
Correct.
Is that really what we're concerned about? Just the threshold asking of a question, or are we concerned more about when that appropriately extended to either a pat frisk or a seizure?
Well, a pat frisk may be an appropriate part of a threshold inquiry if there's a reasonable fear for the officer's safety.
So isn't that what we're concerned about, whether there was a reasonable fear for the officer's safety?
That's certainly the second aspect of this case. The first aspect is whether the police had any right to stop the defendant at all.
To stop or just ask him a question?
Well, they certainly had a right to ask him a question.
Sure.
The case law is settled on that.
Mm-hmm.
They can approach him, they can ask the questions. The motion judge in this case found that the officers were conversational. He rejected the defendant's testimony that the officers were aggressive or threatening in any manner. The officers made no show of authority prior to the point where one of the officers said, "I'm going to pat frisk you now," or asked him if he could pat frisk him, at which point the Commonwealth concedes that there was a stop for constitutional purposes.
Judge Brown got rather steamed up over this.
Yes, he did, Your Honor.
Judge Brown has seen a lot of these cases, hasn't he?
He certainly has over his decades of service to the Commonwealth.
Well, why don't you add up the equation here and tell us what you think justified the initial inquiry and so forth.
Well,
what are the factors that you're relying on?
I would start, of course, by saying that the police did not need a legal justification for their initial inquiry. They are entitled to inquire of any citizen of the Commonwealth, and it is the right of any citizen of the Commonwealth.
Are we in a high crime area?
We are in a high crime area.
Well, let's examine that. Where does that come from?
The officer's testimony.
What part of the officer's testimony?
He says this was an area, I can get the quote, but it's something to the effect of that this was an area where they'd had increasing reports of firearms and shots fired.
Yeah, that is his testimony. And wasn't he cross-examined on that subject?
He was.
And he identified 3 incidents?
That's correct.
One of which was a domestic dispute?
That's correct.
One of which was the finding of a shell?
That's correct as well. And
the other was unidentified, unable to figure out what that was?
That's correct.
All right, so that's it? This is a high crime area?
That's all the incidents he had in his own personal experience. But this court has never suggested that the police must give specific examples of what the crimes are in a specific area to justify.
Does that mean whenever the police officer says there's a rising amount of incidents in this area and the judge then says, well, then it's a high crime area, then all kinds of things can be justified? Does that seem quite right to you?
A high crime area, as this court has frequently pointed out, is simply one factor that the court considers. It certainly does not justify any action unless there are other factors present as well.
But it strikes me that this is a very, but it's used quite frequently as, well, this puts the officers on high alert, this sort of is a lens through which they view all of the actions of the suspect. But I don't see that there's any evidence of substance here that this is a high crime area.
Well, I would point out that this court, again, has never required that. I believe it's, in all the cases, Fraser being the key example, there's never been anything more than testimony of this kind. If this court
But when the officers ask questions, it doesn't seem to be a high crime area at all. So what do we have?
Well, again, there's no incidents known specifically to this particular officer. That doesn't mean that the police don't recognize this area to be a high crime area.
But the only reason it's recognized as a high crime area is the officer says, well, there's been an increase in incidents. So he's cross-examined on it, and it turns into nothing.
Does he have any reason other than his own personal experience that it's a high crime area?
All he said at the hearing was that there had been reports of, increasing reports of firearms and shots fired. There was nothing, as my brother points out and as Justice Gorgeous points out, there was nothing that he could say specifically.
But he said there had been increasing reports of shots fired.
Yes, correct.
So isn't that sufficient evidence then for the judge to warrant a finding that this is a high crime area?
That's certainly the Commonwealth's position, Your Honor.
Mr. Lynn, could you help me in this respect? We have, the majority decision of the appeals court. In your judgment, where did they go wrong legally? I mean, I look through it, and each sentence and each paragraph follows, and they seem to state the law correctly.
Where the appeals court went wrong, with all respect to the appeals court, is despite language to the contrary, they looked at each of these circumstances separately. There's no question there are other reasons why a person might be walking with his arm clenched to his side. There are certainly people in high crime areas have a right to be free from unconstitutional stops. Certainly there are other objects besides a gun that might be in someone's pocket, in someone's jacket pocket. And certainly there are other reasons why an innocent person might be nervous upon being...
isn't it important that the officer didn't make this up out of whole cloth, this hands to the side thing? Didn't he have some training in a course, the police academy, someplace or the other, that this is a typical way that people may disguise firearms?
Yes, he did, Your Honor.
And in a certain percentage, I can't remember what it was, of arrests that turned out to be true?
Yes, in his personal experience, he had made roughly 25 gun arrests over the past year, and he said 10 to 15% of those had involved this straight arm method, which translates to about 3.
The factor that struck me as most telling was that the defendant turned to the side and kept his right side away from the police so that they couldn't see that.
Yes, that's clearly a very important factor. If this is an innocent object, there's really no reason for him to be contorting himself, which is what the judge found, in order to get his license.
But they let him get his license.
Yes, they did.
I mean, the time he reached into his pocket, they didn't fear for their safety, did they?
No, they did not.
And after he took his license out, they took the license over to the car, to the cruiser, and ran an identification check, and they're still standing around while that's all taking place.
I would emphasize that the judge found that they had done that, but he didn't find when. It's not clear from the testimony, but the officers testified that they were both standing there throughout this entire encounter, so it's presumably they did not run the license until after they had just recovered the gun. That's not entirely clear from the judge's findings, but if you look at the testimony, they said they were both there during the frisk.
Well, did they say how much time? Did the judge find how much time, or approximately how much time elapsed between the time he took his license out and the police were looking at it?
I don't believe there was any specific findings regarding time.
But they let him take his license out of his pocket, and that didn't provoke a feeling of fear in the police officers.
Well, what happened was at that moment he took out his license, and he turned around so he would hide his right side from the officer, and that's when he took out his license. And it was as soon as he gave them their license, that was when the officers decided, okay, now I think we'd better conduct a pat frisk because you turned away.
So it was the turning away to get
Right.
the license that added to the suspicions of the police, is what you're saying.
Yes, it's not entirely clear from the record, but I don't think the record as a whole justifies an assumption that they waited for any significant period of time between him producing his license and the pat frisk. So if you look at all the circumstances here together, the straight arm walk, which as Justice Grandy points out, they had experience and training, showed was consistent with holding a gun that's not in a holster. The high crime area, the hour, the nervousness of the defendant, and then most tellingly the weight.
Where was the gun exactly?
The gun was in his jacket pocket, his right jacket pocket, I believe.
Inside?
Inside, yes.
I mean, inside the jacket or in the outside pocket?
I honestly, I believe it was an outside pocket, but I would have to check that, Your Honor. It may not have been specified. Mm-hmm. And you put all of those factors together. It's not any one of them, although certainly the walk is a much more significant factor than the appeals court.
In response to Chief Justice Marshall's question, where did you think the appeals court went wrong? You said it was because they looked at each factor separately, but Aren't you saying, in effect, that where they went wrong was because they discounted the factor of his walking in with the straight arm walk, however you want to call it?
That was the first place they went wrong, but I think the most significant place...
But they didn't discount it. They didn't discount it. What they did is point out that where we've looked at that factor, the police have had some prior information. They're very careful. They look at Fraser, they look at Foster, and they say no. They were investigating a report of a shooting or a report of a gun, and they don't discount it, but they deal with it as a matter of law.
They certainly look at the fact that there was no report of a gun here. But the first thing they talk about, an idiosyncratic walk is not enough to
Well, what they
justify.
say, which seems to me is consistent with what you're saying, is they had a hunch. They couldn't see the gun. There was no flash of metal. They had a hunch. A hunch, perfectly okay in some circumstances based on experience, but it's not as if they discounted it. They dealt with it.
They dealt with it, but I would respectfully disagree with your construction. I think they did both discount it and distinguish it from those cases where there had been an investigation.
What kind of gun was it?
It was just I can't tell you the specifics of it, but it was just a handgun.
A small handgun or a big handgun? We don't know?
I'm not entirely sure, but I believe it was certainly concealable in his pocket, so certainly a small handgun.
Yeah, I think the officer said it weighed about a pound.
Yeah.
If it had been drugs instead of a gun, and would you be here arguing that the observations were consistent with concealment of contraband?
Well, we certainly would have a problem with that, because if the officers had seen this conduct that was consistent with guns and it turned out to be drugs, obviously that's would call the officer's credibility into question. But if the judge found yes, they did still think it was consistent.
So what?
Well, then
they had a legitimate reason to think it was a gun, and it turns out to be drugs. So be it.
Right, but if the judge found that was credible testimony, yes, we'd be in exactly the same place we are now.
But do you pat frisk for drugs or do you pat frisk for guns?
You certainly, if the police have reasonable suspicion that it's a gun, they certainly have greater grounds for a pat frisk, because a defendant may always, anytime you have a gun, especially a gun that they suspect to be illegal, there's always a danger that the person is going to use the gun against the officers to avoid arrest.
Now, this straight arm walking, is it the police's view that if you're carrying a 1-pound gun versus a 1-pound stash of drugs, you walk differently to hide it?
Yes, it's the position. The training of the police officers are that the guns, because of their size and shape and weight, if you don't have a holster, you have to sort of pin it against your side so it doesn't fall out, as opposed to drugs, which conform to the shape of your pocket.
Mr. Lynn, isn't it the case, and it may be that you're legally correct, that a police officer has nothing more than saying a man, an African-American man, is walking down the street doing nothing illegally, but he's walking in a way that this police officer thinks is consistent with he might have a gun. Thereafter, everything is done. The police then choose to put themselves at risk.
Correct.
They don't, as Justice Fina pointed out, they don't pat frisk him immediately. Right?
Correct.
But it's not just that the police think he has a gun, it's that as far as they have been trained to believe, and as this officer's personal experience has been, is a way of walking that conceals a weapon.
That's absolutely correct.
So it's
But
not
you
just
would
his
be
thought.
here, surely if they really think it's a gun, they should stop the man and pat frisk him immediately.
On the contrary, and I think when they have, as you put it, a good hunch that's a gun, it is consistent with respect for the person's constitutional rights to investigate further. And indeed, it's their duty of police officers to do so to the extent they can, consistent with the person's constitutional rights.
Is it fair to say, I think one of the officers testified something to this effect, that what they wanted to do was to keep him talking to see maybe what else he might do?
Yes, correct.
You think that's okay?
That's constitutionally permissible, as long as they don't make a show of authority saying that the person is not free to leave, and the judge found that they did not. They can certainly, that's good investigative technique. It may make a person feel vaguely nervous, but that doesn't amount to a constitutional seizure.
Is a request for identification by two police officers who have stopped you a show of authority?
There is case law that you can ask for identification without, in certain circumstances, without being a seizure, but here that's not an issue because they did not ask for his identification. The judge found that he produced it spontaneously.
So this case is going to stand for, if you prevail, another version of a perp walk?
I'm not sure exactly what you mean in this context by that term.
The way certain criminals walk?
It's I think perp walk is a bad way of putting it. It's a manner of walking that is consistent in both the officer's training and experience with someone who is carrying a gun. It's not just a way that someone is walking to be cool or walking as part of their personal style. I see my time is up. Are there any further questions?
Well, one of the questions is why. Maybe I'm just missing something here, but if one has a gun on one's possession, why would one walk differently if it was an illegal gun as opposed to a legal gun?
You wouldn't accept to the extent that the legal gun might be expected to be in a holster. Anybody who was carrying a gun that was not in a holster would be likely to be walking in this manner.
Well, you're afraid it's going to fall out of your
Exactly.
pocket when there's the cops looking at you. Or you see the cops coming down the street in the cruiser or walking, and you say, oh, my God.
But you don't even know which pocket it was in.
Well, it was certainly on the right side of his body. That was the assumption.
But you don't know if it's inside or outside the jacket.
We don't know.
And so you don't know. I don't know how a gun can fall from out of an inside pocket.
Certainly, any pocket, certainly any one that has a slant to it, as many pockets do, it would certainly fall out of.
Depends on the size of the pocket.
And on the size of the pocket, exactly.
Yeah.
A gun is a heavy and awkward object. It could certainly fall out of just about anything.
Was there a picture of the jacket in evidence, or was the jacket submitted? I mean, is there one of these slash pockets like you can put your hand in?
I would have to. I don't believe any exhibits were admitted. I would have to check, but I don't know.
Maybe it's described in the testimony. Well, okay, thanks.
What was the time this happened?
It was after midnight.
What time of year was it again?
I would have to check.
Okay.
We can
look it up.
Yeah.
Yes.
Thank you, Mr. Lynn.
Thank you.
Mr. Fox?
Good morning. May it please the Court. My name is Robert Fox, and I represent the defendant, Michael DePeiza. And one of the concepts that this Court uses in deciding these cases is the concept of proportionality. The level of police intrusiveness must be proportional to the degree of suspicion. And it comes in two parts, I would suggest. First is the degree of reasonable suspicion needed to effect a stop. And second, which I think is more crucial to this case, is the level needed to conduct a pat frisk. And I believe, based on Terry and this Court's decisions such as Fraser, it requires not only reasonable suspicion of a crime, but immediate danger to the officer or to the public. And I would suggest that that was not the situation here. Fraser lists several factors that were relied on in that case. None of those I suggest are present here. There was no report of a firearm, no shots heard.
But here there was evidence, I take it, that the police found that there is a unique way of concealing an unholstered gun or to ensure that it doesn't fall out of one's pocket, which is to walk the way the defendant was walking. What do you say about that? Why isn't that a signature piece of evidence?
It's a piece of evidence.
But it's a very unique, telling piece of evidence, according to the Commonwealth. What do you say about that?
It's unique. I don't know if it would be unique. I know the officers testified to it. They had
well, he's either
they
carrying
made an observation. They applied their expertise.
Yeah, he's either carrying a gun or a plumbing fixture. Right. And they say that drugs don't fall out of your pocket. They say that sugar doesn't fall out of your pocket. Groceries don't fall out of your pocket the way a piece of metal this size will fall out of your pocket.
And I don't dispute that gave the police cause to start investigating. But that certainly in itself, and I don't think the Commonwealth would claim that would give reasonable suspicion to make a stop. And to the credit of the police, they didn't make a stop at that point.
Would it have been better for the officer to have said to him, what's in your pocket? He could have asked that, could he not? And
I think that would be a more direct way of doing it.
Might that not have put the officer's safety at risk? They might have found out in a way they didn't want to find out.
I'm not a police officer. I don't know what the best way to find out is.
Mr. Fox, surely if you can see that they can stop and ask him something.
I certainly do.
Well, then, doesn't what the police have done thereafter seem eminently reasonable? They didn't ask him to, they didn't pat frisk him immediately. They didn't ask him what was in his pocket. They engaged him in conversation.
I would think that's, for the most part, reasonable.
Then, when they continued to see things that, in their expertise and training, suggested that somebody was trying to conceal something, they then pat frisked him.
I think the level of my client's activities do not rise to the level of reasonable suspicion.
Okay.
The walk certainly is ambiguous.
Well, you've, as far as I can see, just conceded that. Whether or not the walk was ambiguous, you said yes, it was sufficiently clear to them that they could stop and ask him a question.
The next factor that is relied on is the high crime area. I addressed that in my brief. I suggest it should be given very little weight in a case
What
like
about the turning the right side of the body away from the police?
I think a person has a right to maintain his privacy when the police are questioning him.
Were you trial counsel?
I was.
Did they introduce the jacket in evidence?
They did not.
Was the gun on the inside or the outside pocket?
I don't remember if the record is clear on that. I think it was on the outside.
Was there a description of the pocket itself? Did it have a diagonal entry, or was it a vertical drop-in? Did it have a lid over the top?
I don't believe there was a description of the pocket.
As I read the facts, it sounded like he turned several times away from the police. So they were in front of him, he turned, they moved, he turned, then he turned again.
I'm not sure if I read or heard the evidence exactly like that, but he either turned once and remained turned, or he might have turned several times. It's just not clear. But I believe the case law is a person has a right to maintain his privacy. That in itself would not rise to the level of giving the police reasonable suspicion. He was also making sort of movements, I think sideways movements, looking around. This does not rise to the level of flight or furtive movements reaching for a waistband. And that would, again, be an ambiguous action which the police apply their expertise, and it would amount to no more than a conjecture on their part.
Mr. Fox, Justice Brown points out that the straight-arm method is most applicable to rifles and shotguns. Is there anything in the proceedings in the trial court that pointed in that direction?
There was no evidence, I believe, on that issue. I think the police testified that it related to firearms in a general sense. And so...
I have to say, I find it... I have a hard time visualizing what was happening. I can understand what a straight-arm walk is, but it's unclear to me why that would keep a gun in a pocket. One would surely put one's hand in the pocket, or if that's what you were concerned about.
I believe one officer testified it was a straight-arm walk. I think that was Officer Conway, and I think Officer Brickton testified he was holding his pocket.
He was holding his pocket?
That's how I remember the testimony.
I mean, if you just try to visualize a jacket, of which I can't tell what kind of jacket it is, and there's a gun in the pocket, and having a straight arm at the top of my arm doesn't seem to me to help the gun which is in the pocket.
I can't really help you on that.
Do you remember what time of year this was?
April.
This was April, about 12:30 in the morning, I think on a Tuesday morning.
And he's talking on a cell phone, correct?
That's correct. And the next factor that Fraser talked about was the person in Fraser having his hands in his pockets, and that would not apply here. There was no question of that. And I would suggest the other factors that Fraser mentions don't apply here. The police were not outnumbered, so there was no objective report of a firearm. The defendant was not disorderly or unruly. So there was a little bit of difference in testimony about the ID issue. I believe Officer Conway testified that Mr. DePeiza gave the ID voluntarily. That was also Mr. DePeiza's testimony.
What does voluntarily mean? Was it unrequested?
Yes, I believe it was unrequested.
Well, they were asking him questions, who he was, where he was living, and he said, well, I've got an ID.
Yeah, they approached him and didn't ask, are you carrying a firearm, or who are you? They said, yo, Dwayne, not his name. It'd be reasonable for someone to be worried, at least to think he might be accused or mistaken for someone else who might be a serious criminal.
Was it clear that they were police officers when they said, yo, Dwayne? This was an unmarked car.
It was an unmarked car. I think there was testimony that they had identification around them. Whether that would be readily apparent to my client.
So this is, in a high-crime area at night, somebody calls out from an unmarked car, yo, Dwayne.
And that would cause a reasonable person to be apprehensive and maybe make movements indicative of his worry and fear. Was
there testimony about the police going back to the car with the identification before making the pat frisk?
I believe Officer Conway said he went back to the car to check the ID.
But was that before or after the pat frisk?
I understood it as being before. The transcript, I don't know if it says specifically, but that was the...
Well, the officer says, was it before the pat frisk? I guess it. Honestly, sir, I don't know. That's the testimony on the subject. The other officer says, no, it was not before the pat frisk. We would never have, we were worried. We would have never sent somebody back to the car. So there's it's quite unclear.
Right.
And the judge's findings just sort of put it in a parenthesis that doesn't really place it at any point in time either.
So the act of my client reaching near where the gun was, I believe the testimony was he reached for his right pants pocket where his ID was. He had to go near the gun, went past it for his ID, and he was turning around. If that wasn't making the officers in fear, then there's nothing afterwards that would justify them conducting the pat frisk.
Well, I think that there's no testimony that would warrant a finding that the police officers went to the car before the pat frisk. If the only testimony is, as Justice Cordy just said, one officer says it was after the pat frisk, we would never do it before because of fear for our safety, and the other one says, I don't remember. There's no evidence from those two statements that would warrant a finding, in my mind, that they went back to the car before the frisk. There's no testimony that they went back to, I don't remember, isn't positive testimony.
I can't argue with that.
Okay, so there's no evidence that they went back to the car and left him alone with a gun.
Well, they never left him alone. I think it would have just been Officer Conway.
Left him one-on-one with a gun.
So it would have been one-on-one. But even if there is no such finding, the fact that they accepted the ID, and I think that's clear that they accepted it before the pat frisk, I would suggest when they accept the ID and don't return it, that would amount to a stop.
But they said that, I take it that the significance is that when he handed him the ID, he turned his right side away from them, and that's what gave them additional suspicion that that he was trying to conceal a gun. What's your response to that?
I would suggest that's not enough to make their opinion more than a hunch or a conjecture.
Well, doesn't it confirm their suspicion that he was carrying a gun from the way he was walking?
I don't believe it does. It just confirms that he has a privacy interest in his pocket. And I don't believe that's enough for the police to make a stop and conduct a pat frisk at that point. And
what should they have done? You concede that they saw him walking in an unusual, different, whatever you want to say, a suspicious manner. And you say they should not have asked him for his identification. What should they have done? They didn't have If they didn't have his turning away, then they wouldn't, clearly, in your mind, wouldn't have enough for a pat for. So what should they do if there's someone they suspect is carrying a gun? Dangerous. So what are they supposed to do?
It might be a case where they just have to let the person move on and make
shoot
further
somebody?
observations.
And shoot somebody? Is that good police work?
I don't think there is a presumption that a gun is inherently dangerous.
Oh, yes, there is. We give that instruction every day. A gun is as a matter of law, a dangerous weapon.
It's a dangerous weapon, but in terms of the crime of carrying a dangerous weapon, yes. But in terms of requiring a pat frisk, the fact that someone may have a gun does not mean that it's illegally possessed. There are no other.
Even if it's legally possessed, it's still a dangerous weapon.
It is a dangerous weapon, but only potentially dangerous. It's not immediately dangerous. This is not a situation where my client was unruly or disorderly that might indicate he would be inclined to use the gun soon, or that he was drunk, or that he was showing the gun off. There was just no indicia of dangerousness other than the police suspicion, which I suggest was not reasonable, was not supported by specific and articulable facts. And
You mean they have to have a suspicion that it's an unlicensed gun?
I think...
Can't they stop anybody that's carrying a gun and say, do you have a license to carry this gun? Let me see it.
That issue, I think, was raised for the first time in the Commonwealth's brief here. It was not raised at the trial court or at the appeals court.
Chief Justice DePeiza, in his dissent, seems to say that this behavior is consistent with actions of persons known to conceal illegal firearms, and that's why I don't know what the basis of Chief Justice DePeiza's conclusion is.
I'm not sure either.
Well, at the end of the day, it doesn't matter. I mean, what we're talking about here is a field stop or field inquiry. You don't need reasonable suspicion that a crime has been committed or is about to be committed to conduct an inquiry of that sort. Just who are you? You know, it's 12:30 at night. Who are you? What you doing? That's certainly reasonable. It's not a seizure for constitutional purposes. The question is whether they had a belief that they were in danger. They don't need reasonable suspicion that a crime is being committed to do a pat search. All they need is a basis to conclude that they are in danger. Isn't that correct?
That would be correct, but I would suggest that nothing...
And someone can be in danger from a legal firearm as well as an illegal firearm.
Right, but I don't think danger is presumed. I think there are usually specific facts for danger.
I think you're right about that. So that's the question.
And I would suggest there isn't. If there are no further questions, I would request that the court reverse the trial court's judgment, and thank you.
Thank you, Mr. Fox.